আমরা দেখতে পাচ্ছি আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের যে বাইরের দৃশ্য, ইতিমধ্যে প্রচুর গণমাধ্যম কর্মী সেখানে সমবেত হয়েছেন। আমরা দেখছি রায়।
14 ডিসেম্বর এটা ফিক্স আছে আগে থেকেই। আইটেম 3 নেক্সট ডেট আগে থেকেই ফিক্সড আছে, আর আইটেম 2 এর নেক্সট ডেট আমরা 25 তারিখে চাচ্ছি।
25 তারিখ, ঠিক আছে।
মাচ অবলাইজ।
May it please your lordships. My lord, in this item we are, on behalf of the prosecution, we are here for receiving the judgment, and I beg your lordships very kind permission as per section 9A2 for broadcast of the session, my lord.
Including dais?
No, excluding the dais. Much obliged, your lordships.
Much awaited judgment. Before incepting reading out the judgment, I want to extend thanks to the investigation team headed by co-coordinator for the conducting of the strenuous job. They have done a very tough job, I will say, the investigation team. And I like to mention of Mr. Alamgir, investigating officer, and Mr. Joha, and other members of the investigation team. Many thanks to them. Thanks to my bench officers, assistant bench officers, and those who operated our devices and machineries, including Mr. Meher. He has done a lot in the preparation of the judgment. I also like to extend thanks to my registry, to all the staff, and to the respected journalists who have been working very hard to collect the informations of this tribunal during the last a long period. And we are very much thankful, grateful to the members of the martyrs and those who have been injured, who have lost their eyes, their skulls, their nose, teeth, legs, hands, handicapped. In spite of being handicapped, they attended the court. They deposed the court, and they assisted in the running of the trial of the case. We are thankful to our police personnel and all other security staff, BGB, SB, DB, Metropolitan Police, and all others. And many thanks to those who have come to depose in the court. And very much thankful to the prosecution. The learned prosecutor, Mr. Mizanul Islam, Mr. Ghazi Manoarul Hussain. They played a substantial part in the trial. And I will mention the other names of the prosecutors who have also contributed to some extent from time to time during the proceeding of this case. And they are Mr. Sultan Mahmood, Mr. Shahidul Islam Sardar, Mr. Farooq Ahmed, Mr. Abdullah Al Numan, Mr. Abdul Sattar, Mr. Mamun Rashid, MD Hassanul Banna, SM Moinul Karim, Mr. Saikul Mahdi, Mr. Tariq Abdullah, Mr. Our staff, whose names I could not mention by this time. Our heartfelt thanks to the learned Attorney General, who have attended the trial at the inception and at the conclusion. Over and above, our thanks from the core of our heart to Mr. Tajul Islam, the learned Chief Prosecutor, for playing the part of excellence. We are thankful to all others. Thank you all. Now let us say something about, I am sorry, I am very much sorry. Our sincere thanks to the learned defense lawyers, particularly the learned State Defense Lawyer, Mr. Amir Hussain. Many people will say many things, but he has done a lot. And he, in our view, in our estimation, to the best of his possibility, he played the exact role he was supposed to, and that we expected. Thanks to him again. And if anyone is left, sorry that we do not by this time recollect. Our thanks to the learned Attorney General again for his kind presence. We are sorry for being late because many things are connected in the preparation of the judgment. This is a very big matter. For the last couple of days, we could sleep very little, and we had to work continuously for 10 to 12 hours every day. So, anyway, this is our job, but all of you are waiting. You have participated in many ways. Thanks to you all. Now let us discuss something about the judgment. I want to give an idea of the judgment. The judgment comprises 453 pages. And it consists of 6 parts. The first part includes the index, description of the prosecutors, learned prosecutors and the learned defense counsels, introduction of the accused, origin and object of the tribunal, jurisdiction of the tribunal, Article 7 of the Rome Statute, which is the basis of trial of our tribunal, elements of the crime against humanity. We are trying the offense, we are holding trial of the crime against humanity. So, elements of crime against humanity, these are enunciated by the Rome Statute and being followed and exercised by the International Criminal Court and other international tribunals. We are also following the Rome Statute as well as our law, and particularly the elements as enshrined therein. And elements of superior command responsibility. In such cases, superior command responsibility is bulkily involved, and that's why we have to have regard to this aspect as well. And we have stated the standard of the tribunal. That is, we compared the standard of this tribunal with the standard of the other international tribunals as well as the International Criminal Court. And we have said about the trial procedure, Part 2, pre-trial proceedings, Part 3, prosecution story and defense case. We have stated about learned Chief Prosecutor's submission on charge, learned State Defense Counsel's submission on charge, thereupon decision on charge, and then we have given the description of evidences in Part 4. In Part 4, we have also given an account of the testimonies of the prosecution witnesses. In Part 5, we have given the illustration of the evidences, that is the discussion of the evidences. Used arms and ammunitions. We have given an account of the used arms and ammunitions. We have given a description, we have discussed about the telephonic conversations of accused Sheikh Hasina with a number of persons from time to time. We have discussed and extracted the reports of daily newspapers concerning the issues of this case, reports of United Nations Human Rights Commission, reports of Odhikar, another Human Rights Commission, reports of Human Rights Watch, and Globe Institute, and so on. We have discussed about the videos of the occurrences which have been displayed in the tribunal. And we have described the extent of cruelty administered upon the victims who have died and who have been seriously injured and lost their vital organs of the body. And we have talked about seized alamots. We have given account of the murders, number of murders, in accordance with the Gazette notifications published by our government and in accordance with the reports of United Nations Human Rights Commission and other organizations. In this context, I want to say that the exact report of martyrs or the victims or the sufferers or the injured persons or those whose whereabouts could not be traced, this is quite natural. You will understand that since our liberation war in 1971, still we could not finalize the list of martyrs, the list of freedom fighters, list of the war criminals, and others. So there are lists, but it varies. So it's a timely matter. It may vary. Somewhere you will find the figure 800, somewhere 1,000, somewhere 1,400. So substantial amount of the protesters have been killed. This is the fact. We have described the police messages and directions passed from the high-ups to the downwards for doing the needful to control the protesters, curfew orders. Then in Part 6, we have described, we have given an account of the learned Chief Prosecutor's arguments, the points of arguments, pertinent points of arguments have been described. We have also described the pertinent points of arguments raised by the learned State Defense Counsel. Thereafter, we have given an account of our observations and inference. And finally, we passed the order. So this is all about the judgment. Now we will read out the very pertinent portions of the judgment one by one. At first, our learned member 2, he will read out a portion of the judgment commencing from origin and object of the tribunal, jurisdiction of the tribunal, and he will read out Article 7 of Rome Statute, elements of crime against humanity, elements of superior command status, responsibility, and then the charges. Thereafter, learned member 1, he will read out some portions from the discussion of the evidences, the report of the United Nations Human Rights Commission, and then the extent of cruelty administered upon the victims, and thereafter the points of arguments submitted by the learned chief prosecutor and the learned State Defense Counsel. And finally, I will read out the conclusion and the order. So it will take about 40 minutes. We hope that you will be listening to the deliberations. Thank you very much. Now, the turn of our learned member 2, he is reading out, as I have mentioned.
Origin and object of the tribunal. The International Crimes Tribunal has been established under the International Crimes Tribunal Act 1973 to provide for the detention, prosecution, and punishment of the persons for genocide, crimes against humanity, war crimes, and other crimes under international law committed within or beyond the territory of Bangladesh, whether before or after commencement of the Act. Jurisdiction of the tribunal. The tribunal has got the jurisdiction to try the offences enshrined in Section 3 and 4 of the International Crimes Tribunal Act 1973. Section 3 provides, a tribunal shall have the power to try and punish any individual or group or individuals, organization, or any member of any disciplined force, auxiliary force, or intelligence agency who, irrespective of his nationality, commits or has committed within or beyond the territory of Bangladesh, whether before or after the commencement of this Act, any of the crimes mentioned in its subsection 2. According to subsection 2 of section 3, the following acts or any of them is crime within the jurisdiction of a tribunal for which there shall be individual responsibility. The Constitution of Bangladesh has given upper hand in Article 47, subarticle 3 thereof to the application of the provisions of International Crimes Tribunals Act 1973 in the following manner. Notwithstanding anything contained in this Constitution, no law nor any provision thereof providing for detention, prosecution, or punishment of any persons who is a member of any armed or defense or auxiliary forces, or any individual group of individuals or organization, or who is a prisoner of war for genocide, crimes against humanity, or war crimes and other crimes and crimes under international law, shall be deemed void or unlawful, or ever to have become void or unlawful on the ground that such law or provisions of any such law is inconsistent with or repugnant to any of the provisions of the constitutions. Crime against humanity, namely murder, extermination, enslavement, deportation, imprisonment, abduction, confinement, torture, rape, sexual exploitation, enforced disappearance, human trafficking, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or other inhuman acts when committed as part of a widespread or systematic attack direct against any civilian population with knowledge of the attack, or persecutions on political, racial, ethnic, or religious grounds, whether or not in violation of the domestic law of the country were perpetrated. Section 4 provides as follows. Any individual or groups of individuals or any member of any discipline force, auxiliary force, or intelligence agency who commits a crime within the jurisdiction of the tribunal shall be responsible and liable for a punishment. Any commander, superior officer, or leader who orders, permits, acquiesces, incites, or participates in the commission of any of the crimes specified in Section 3, or is connected with any plans or activities involving the commission of such crimes, or who fails or omits to discharge his duty to maintain a discipline or to control or supervise the actions of the persons under his command or his subordinates, whereby such persons or subordinates or any of them commit any such crimes, or who fails to take necessary measure to prevent the commission of such crimes. Now, crimes against humanity according to Rome Statute. For the purpose of this statute, crime against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with the knowledge of the attack. A. Murder. I am reading the relevant ones. Murder, torture, other inhuman acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. The core offense in the instant case is the crime against humanity. Thus, we have to see what elements are required to constitute this crime. In Section 4 of the Act, there must be an attack. B. The attack must be widespread or systematic. C. The attack must be targeted a civilian population. D. The attack must be within the knowledge of the superior, or the superior should have known of the attack in order to hold him or her liable for the crime. The superior must have been in the control over the concerned subordinates. Elements of superior command responsibility. From the jurisprudence and eminent from the international crimes tribunals, it is generally agreed that 4 elements must be proven for a person to be held responsible as superior. The elements are: 1. An international crimes must have been perpetrated by someone other than the accused. 2. There existed a superior-subordinate relationship between the accused and the perpetrator. 3. The accused as a superior knew or had reason to know that the subordinate was about to commit such crimes or had done so. 4. The accused as a superior failed to take the necessary and reasonable measure to prevent such crimes or punish the perpetrator. Section 4, subsection 2 of the International Crimes Tribunal Act provides that any commander or superior officer who orders, permits, acquiesces, or participates in the commission of any of the crimes specified in Section 3, or is connected with any plans and activities involving the commission of such